The Supreme Court just agreed to hear another massive gun rights case that could change everything for millions of Americans living in restrictive states. Several states passed new laws after the Supreme Court told them they couldn't restrict concealed carry permits. But instead of following the court's orders, these states found a sneaky workaround. Now the Supreme Court is stepping in again to settle this fight once and for all. The case is called Wolford versus Lopez, and if you live in New York, New Jersey, California, Hawaii, or similar states, you need to pay close attention because this case directly affects your ability to carry a firearm for self-defense. A few years ago, the Supreme Court ruled in New York State Rifle and Pistol Association versus Bruin that states couldn't make it nearly impossible for regular citizens to get concealed carry permits. That should have been the end of it, but several states basically said they didn't care what the Supreme Court says and passed new laws designed to get around that ruling. Hawaii is at the center of this new case, though they're not alone. Multiple states did the same thing. Here's how these states are trying to sidestep the Supreme Court's previous ruling. They created a new default rule where even if you have a valid concealed carry permit, you cannot carry your firearm on any private property that's open to the public unless the property owner posts a sign saying you can. Think about what that means. You can't carry in grocery stores, shopping malls, restaurants, gas stations, or pretty much anywhere unless there's a specific sign saying concealed carry is allowed. It flips everything upside down. For years, the standard was simple. Property owners who didn't want guns on their property posted no gun signs. That was their right, and everyone respected it. But now these states are saying the opposite. Every business is automatically a gun-free zone unless they post permission. The result is that almost nobody can actually exercise their concealed carry rights, even though they technically have a permit. A group of citizens and gun rights organizations sued Hawaii over this law, arguing it violates the Second Amendment. At first, they won when a district court judge agreed with them and issued a preliminary injunction temporarily blocking the law. But Hawaii appealed to the Ninth Circuit Court of Appeals, which is known for being hostile to gun rights, and they sided with Hawaii, saying the law was perfectly fine. The plaintiffs then asked for an en banc review, wanting all the judges on the Ninth Circuit to reconsider the case. But that request was denied even though some judges strongly disagreed. That left one option: take it to the Supreme Court. Here's where things get interesting. The Trump administration's Department of Justice, led by Attorney General Pam Bondi, filed a brief supporting the challenge to Hawaii's law, basically saying these concealed carry restrictions are unconstitutional and should be struck down. This may have been a game changer because the Supreme Court has been denying emergency appeals and Second Amendment cases for a while, but this time they agreed to hear the case with oral arguments scheduled for January 20th. Even better, the Trump DOJ has asked the Supreme Court for permission to participate in those oral arguments, meaning the federal government would be arguing on the side of gun rights, not against them. This case has split the country right down the middle. 25 states have filed a brief supporting the challenge to these concealed carry restrictions, arguing that laws like Hawaii's violate the Second Amendment and should be struck down nationwide. On the other side, 18 jurisdictions including the District of Columbia, Illinois, California, Colorado, Connecticut, Delaware, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New York, Oregon, Rhode Island, Vermont, and Washington have filed a brief supporting Hawaii. Many of these states have similar laws already on their books, so they're not just defending Hawaii but their own restrictive laws too. The 18 states defending Hawaii's law are making a clever argument, claiming this isn't even a gun control law but just a neutral rule about private property rights. Their logic is that property owners have the right to exclude anyone from their property for any reason, so the government can create a default rule that assumes all property owners want to exclude guns unless they say otherwise. They even point to surveys suggesting that most people in Hawaii support this kind of law and argue that forcing business owners to post no-gun signs puts an unfair burden on them. But there's a major problem with that argument. Property owners always had the right to ban guns from their property through posting signs or telling people verbally, with trespassing laws protecting their rights. Nobody was forcing them to allow guns. What's different now is that the government has stepped in and made the decision for all property owners across the entire state. It's no longer a personal property choice, but a state-mandated prohibition that applies everywhere unless a property owner actively opts out. The pro-restriction states take an extreme position, arguing that the right to bear arms literally stops at the property line of any business because property owners can exclude guns, so the government can do it for them by default. But the government isn't just protecting property rights. It's creating a blanket ban that affects millions of people across an entire state, transforming a personal choice that each property owner could make into a one-size-fits-all government mandate. And they conveniently ignore how this squares with the Second Amendment, which protects the right to keep and bear arms. When the government creates rules that make it nearly impossible to actually carry a firearm in public, doesn't that violate that right? The question before the Supreme Court is very specific. Can Hawaii prohibit licensed concealed carry permit holders from carrying handguns on private property open to the public unless the property owner gives express permission? The Supreme Court will have to apply the same test they used in the Bruin case, which looks at the text, history, and tradition of the Second Amendment to determine whether the founders intended for the government to have this kind of power and whether there's historical precedent for these restrictions. This case will be huge for Second Amendment law, giving the Supreme Court another chance to clarify what the Bruin decision means and how lower courts should handle gun rights cases going forward. Even if the Supreme Court strikes down these laws, here's the hard truth. Many anti-gun states will probably just try to find another workaround. They did it after Bruin and will likely do it again. Some states will openly defy the Supreme Court, while others will craft new restrictions that they claim comply with the ruling while still making it nearly impossible to exercise gun rights. But that doesn't mean this case isn't important. Every Supreme Court victory matters, and every time the court reaffirms that the Second Amendment means something real, it makes it harder for states to chip away at our rights. Oral arguments are scheduled for January 20th, and after that the Supreme Court will deliberate and eventually issue a ruling, which could take weeks or even months. This case affects millions of Americans who simply want to exercise their constitutional right to self-defense. And whether you live in Hawaii, California, New York, or any other restrictive state, this decision will matter to you. The Supreme Court has a chance to make it clear that states can't just ignore their previous rulings or create elaborate workarounds that make constitutional rights meaningless in practice. Claude is AI and can make mistakes. Please double-check responses.